The International Criminal Court arose during the 1990s essentially as a response to what was seen as a compelling need at that time, and that was to achieve international criminal justice with respect to perpetrators of atrocities, such as those occurring in Bosnia-Herzegovina at the time, the genocide in Rwanda in 1994. The Security Council had built special tribunals for the accountability for the commission of these crimes. But that's a very expensive proposition, tribunal by tribunal by tribunal, all the judges and prosecutors and investigators and buildings that have to be dedicated to a single set of atrocities in a single part of the world is an expense for the United Nations to do that. So the advantage of the permanent court is that you have a sitting set of 18 judges. You have a prosecutor and a large prosecutorial team, you have defense counsel, you have investigators, and you have a permanent building in The Hague, Netherlands, whereby atrocity situations can be brought to be investigated and adjudicated. The Permanent International Criminal Court deals with 4 particular crimes under international law. The first is genocide, which many of you may be aware of, particularly in terms of the existence of the Genocide Convention, the reality of the Holocaust, the reality of what occurred in Cambodia in the late 1970s under Pol Pot, and the reality of so many other genocide situations that erupt in the world. And that crime involves particular individuals who have the specific intent, like the very narrow intent, to destroy all or a substantial part of an ethnic, national, racial, or religious group as such. In other words, the aim is wipe them out, wipe out that group. That's the crime of genocide. The next set of crimes is crimes against humanity. And this is a targeted, systematic, or widespread assault on a civilian population, and it can involve killing, it can involve persecution, ethnic cleansing, it can involve forced deportation, it can involve a whole list of particular types of crimes that you would know as common crimes, but they're done in the aggregate against a large number of people. It's a magnitude crime, crimes against humanity. You don't have to have any specific intent to wipe out a group, as you do in genocide. Your intent is get them out of here or kill them. That's your intent. And so that crimes against humanity is actually the one that is most commonly prosecuted by the war crimes tribunals of the 1990s, as well as the Permanent International Criminal Court. And then you have war crimes, which are committed during war. Remember, genocide and crimes against humanity, you don't actually have to have a war for those crimes to be committed. Oftentimes there is a war, but you don't have to. With war crimes, you have to have a war with 2 armies contesting each other, or one state army fighting a guerrilla force on another territory or even on their own territory. It's a combat situation. War crimes have been around for a very long time in terms of our knowledge of them. It reaches all the way back to the late 19th century that we began to codify the prohibition of war crimes. And of course, it culminated with the Geneva Conventions of 1949 and then their protocols of 1977. So there's a lot out there on war crimes. And in the Rome Statute of the International Criminal Court, there's a lot of information about war crimes in terms of how you define them. What exactly are they? Event by event by event. It took years to negotiate that checklist in the Rome Statute because it draws not only from the Geneva Conventions, but it also draws from what we call customary international law. What has emerged over the centuries that we all know is a war crime. That's customary international law. And then finally, there's the crime of aggression. The crime of aggression is often sort of viewed as the father of the other crimes. In other words, if you commit a war of aggression, there's a good chance you may end up also committing genocide or crimes against humanity, and certainly war crimes. So the crime of aggression is a trigger mechanism for intense criminal activity, particularly by the aggressor force. Now, the International Criminal Court has not had an aggression case yet, and so therefore we don't have what we call the jurisprudence of the court to understand better how judges would adjudicate the crime of aggression. But it is there. The International Criminal Court prosecutes only individuals, not governments. Governments are brought to justice before what's called the International Court of Justice in The Hague, which is a UN court. The International Criminal Court is not a UN court, and it only pursues individuals, those who actually are responsible for orchestrating the commission of any of the 4 crimes within the jurisdiction of the court. Namely, these are the masterminds, the leaders. The court does not go after the foot soldier or the low-level ranking individuals who might be caught up in actually committing these crimes. Rather, it's those who orchestrate them doing so that are brought before the court, the leaders who are brought before the court. Individuals who are convicted before the court are punished by imprisonment. There is no death penalty whatsoever at the International Criminal Court. The penalties can extend to many, many years and potentially even life when those convictions are handed down. And they are then imprisoned in various prisons in countries that have entered into agreements with the court to say, yes, we'll accept a convicted individual and detain this individual for the length of his or her sentence in a coordinated fashion with the court. The major challenge for the International Criminal Court now is to expand its membership in the world. Currently there are about 125 member states, but major powers in the world are not party to the court. That includes the United States, it includes Russia, China, Indonesia, India, Pakistan, Saudi Arabia. Those are large countries, and the fact that they are not party to the Rome Statute means that the ability of the court to actually take up atrocities is limited, because those countries actually represent large swaths of territory and also huge populations. And so those are all off deck from the court. And if one could, we call it, establish a more universal membership in the court, then the court's relevance with respect to the commission of atrocities across the world would be enhanced and strengthen the court.